Hello, I'm Larry Gostin, Legal and Global Health Correspondent for JAMA, and from the O'Neill Institute for National and Global Health Law at Georgetown University Law Center. We're here today to talk about the ethical and legal concerns for clinicians since the overturning of Roe v. Wade. I'm joined today by visiting professor at Georgetown Law, Michele Goodwin, Chancellor Professor at the University of California, Irvine. She heads the Center for Biotechnology and Global Health Policy at UC Irvine. Dr. Lisa Harris, a professor in the Department of Obstetrics and Gynecology and the Department of Women's and Gender Studies at the University of Michigan, and Molly Meegan, Chief Legal Officer and General Counsel of the American College of Obstetricians and Gynecologists, known as ACOG. And I thought I would start with Molly in her legal expertise. If she could just give us a little bit of a background about state abortion restrictions and the potential penalties faced by clinicians in states that have abortion bans.
Thank you. Even prior to the Dobbs decision, states had ramped up the number of restrictions and bans on abortion that they put on their books in anticipation of what was going to come after Dobbs. I really do look at Texas with SB 4 and SB 8 as one of the initial sort of parties that started this chain. Texas put into place not just criminal prohibitions on abortion and criminal penalties for providing abortions in ways that violated the Texas statutes, but they also empowered their citizens to sue abortion providers or anyone who aided or abetted the obtaining of an abortion. Since Dobbs, we see across the country a huge variety of statutes, from criminal statutes, some of which find that the provision of an abortion is murder, a number of which provide very serious criminal penalties up to 10 years in jail, financial penalties as well. And then we see these civil statutes that allow individual citizens to pursue the family members of somebody obtaining an abortion, the clinician that's providing the abortion, or all of these surrounding medical professionals that may be in that room as well, to statutes with exceptions for really narrowly defined medical emergencies that aren't practical from a doctor's perspective. They don't apply to the real life situations that they see. We're also seeing shield laws in a number of protective states that purport to protect their clinicians from prosecution in another state. They have also sometimes provisions which allow a countersuit to offset any damages that could come from a civil lawsuit in a different state. So it's a real patchwork at the moment.
There's not just a patchwork, but clinicians face real legal peril. Michele, I mean, you are a law professor, but you're also one of the world's most esteemed ethicists. And I wonder if you could talk a little bit about the ethical concerns around privacy, surveillance of clinicians and patients, and also talk a little bit about how clinicians themselves face enormous ethical challenges by these restrictive abortion laws.
You're right that these are grave ethical concerns that clinicians are facing, that people who are adjacent to clinicians and hospitals are facing, and what this means for patients. So we're at a time, even leading up to Dobbs, where lawmakers were coercing clinicians to read scripts that were inaccurate to patients who desire to have abortions, forcing them to say things that were just absolutely untrue. This abortion will cause you to have breast cancer, future depression, things like that. Clearly unethical in those instances, but now a different brand of lacking of ethics. That is to say, being denied life-saving services, even fundamental healthcare services to patients that need them. It's a very coercive space to place clinicians in. There are oaths that they take. There are ethical responsibilities that they have. And here we see state lawmakers intervening against that. And one last feature that I would say that's beyond ethics, and we could go down a laundry list of the ethical concerns here, including turning over private patient information to law enforcement, or law enforcement seeking to have warrants to get private information. But we also have to understand that these laws, Larry, now no longer have exceptions for cases of rape or incest. This is a feature of these laws that we would not have seen even 5 years ago. And even in those instances where there are exceptions for rape or incest, there are state laws that are requiring those individuals to file police reports, and sometimes more than once.
Lisa, you have vast experience on the ground and are in touch with key abortion providers around the United States. So talk a little bit about what it's like to be down on the ground in these kinds of situations.
Yeah, so I am a physician in Michigan, and I will talk broadly about what I'm hearing from my colleagues nationally. But Michigan is an interesting case study because we have a 1931 law on the books that's a complete abortion ban, with the only exception being to preserve the life of a pregnant woman. So we've been able, though, to continue to provide care since the Dobbs decision because of a series of temporary restraining orders and preliminary injunctions and ultimately a permanent injunction. But uncertainty has been the main feature of this time since Dobbs. We didn't know for sure if our ban would go into effect. Even once we had a restraining order, we didn't know if it would be extended. So day to day, we haven't actually known in the state if we were going to be a ban state or if we were going to be a place where people come when they can't get care in their own homes. We're right next door, obviously, to Ohio and Indiana. And through this period, they've had their own bans. So on the ground, what I'm seeing because of our injunctions is an enormous surge in patients coming to Michigan, as much as a doubling of the number of patients we've seen in our hospital acute care setting, a 40% increase in patients in our outpatient setting where healthier patients can be seen. And all of that increases from people coming out of state. The problem with the uncertainty, though, is that we also have to say to patients, well, we can see you today, we can plan your care for later this week, and this is particularly true for complex patients that need a lot of preoperative management. And then we have to say, but we don't know if when your OR day gets here, abortion's still going to be legal in the state. And you can imagine that that causes so much distress among patients. So we're managing much more distress than we ever have before. And it causes distress among care providers as well, because we don't know moment to moment if our work and care for the people who are in our waiting rooms is going to be legal. There was one day in Michigan where the legal status of abortion changed literally 3 times over the course of the day. We had patients waiting for us. We had to send them home. We could call them back. And I think what I want to emphasize, it's not just whether we know we're a ban state or a surge state that matters. The uncertainty itself in this moment is having an effect on patients' experiences and caregivers' experiences.
I wanted to, just pick up quickly with you, Molly, on the uncertainty for clinicians, just to talk a little bit about clinicians and the kinds of choices they face, which threatens their career and even freedom, but also that of their patients.
These laws are having a chilling effect, and I would argue that, in fact, that's primarily the intent. While litigation throughout the country now is focused on sort of the language of the law, no individual clinicians or patients have been charged yet, although I'm sure that will happen. The fact of the matter is doctors throughout the country have stopped providing essential, basic, necessary medical care to their patients because they're scared of the ramifications of these statutes. And the ramifications aren't just criminal or civil prosecution. They're also an effect on their medical license. They're an effect on their medical malpractice insurance premiums. So a physician that is faced with a law that doesn't clearly allow them to operate in situations where they have to operate, medical emergencies, inevitable abortions, spontaneous abortions, incomplete abortions, or simply a situation where a woman needs to access abortion care for particular reasons that may be specific to her situation, the clinicians don't feel that they can. And that does place them in a terrible ethical quandary. They cannot satisfy what they believe is their job, the oath that they took to serve their patients to the best of their ability and provide them with unbiased and expansive reproductive health care and still comply with the laws. It's impossible to do both.
Very shortly after Ohio's ban came into effect, which is the very day that Dobbs was handed down, In Michigan, where we could still provide care, we began seeing patients with life-threatening ectopic pregnancies where doctors out of state were not comfortable proceeding with what would have been routine care the day before because of the new ban in Ohio. So if that's not a chilling effect, I don't know what is.
It's worth noting a few things here, Larry, if we level set, to just understand the landscape. Roe v. Wade was a 7-2 opinion. 5 of those 7 justices were Republican appointed. Justice Blackmun, who wrote the opinion in Roe v. Wade, was placed on the court by Richard Nixon. And that really helps to give us some sense of the landscape at that time, because the Dobbs decision is written as if this is the strangest thing that ever happened, that there was always this political polarization. It's not true. I say that because the clarity is really necessary when we talk about these issues in these times, and when we think about the intersections of law and also bioethics. We have to understand that Roe v. Wade wasn't the first time that the Supreme Court was articulating a civil liberty, a civil right associated with parenthood. In 1942, in the case Skinner v. Oklahoma, the Supreme Court used the language of human rights and civil rights to describe an individual's ability to be able to determine their own reproductive future. I think that's important for a level set, but now I want to get to preemption. This Supreme Court term wasn't just about Dobbs. Dobbs was at the end, but the beginning of the term was really about the challenges to SB 8, that Texas law that banned abortion after 6 weeks of pregnancy, with no exceptions for rape or incest. In many ways, it set the table for what was going to happen at the end of the term. And in many ways, it told us all that we needed to know when the Supreme Court responded as if its hands were tied. This is the Supreme Court of the United States. Its very first iterations in court cases where we are the Supreme Court of the land. We are the supreme of the land. We can intervene anywhere that we need to. And so to see the Supreme Court suggest that its hands were suddenly tied in a law that directly contravened Roe v. Wade was something that was stunning. And what makes Dobbs such a chilling decision is that you see a failure to even grasp and deal with the questions of maternal mortality, which, when we look at this as a global affair, the United States leads all developed countries, industrialized countries, in maternal mortality. We know that a woman is 14 times more likely to die by carrying a pregnancy to term than by having an abortion in the United States. Even the Supreme Court in 2016 mentioned that in Whole Woman's Health v. Hellerstedt. So EMTALA, the Emergency Medical Transportation and Labor Act, is one where President Biden has said will be placed in full effect and full force to make sure that doctors understand that they can respond to the medical crises that pregnant patients may experience and to stabilize them with an abortion that they may need.
The best estimate is that under a complete abortion ban, overall maternal mortality in the US would go up 21%. But because we have such disparities in maternal mortality by race, that increase is not going to be felt equally. The estimates are that maternal mortality would go up about 13% in white women and 33% in Black women. And that's because, as Michele pointed out, ending a pregnancy is so much safer than continuing a pregnancy and giving birth. And those data come from a study by Amanda Stevenson from last year, and they don't actually even account for death from unsafe abortion, which is a risk as well. If someone can't access abortion in the state in which they live, there are really only 3 paths. They can travel and leave the state, they can self-manage an abortion, or they will give birth. And the data suggests that many women will not be able to travel. Most women who seek abortion care live under the federal poverty level or live on just 1 to 2 times that. Almost 60% in Michigan, it's almost 70% of women are mothers already, which makes travel more complicated. So, leaving the state is not an option for everyone. Self-managed abortion with medications may be a safe path for many people. There's excellent data from around the world that mifepristone and misoprostol alone are both safe ways for people to self-manage abortion. So that may help some. However, not everyone will have access to those medications. They may not have a private way to receive them in the mail. They may not have a credit card to pay for them. And even though they're safe, I'm actually worried about the legal danger many women will face, that receiving these medications or coming to a hospital for care after using the medications could result in prosecution or being reported to the authorities. And it's very clear, even in a pre-Roe world, that the burden of arrest and detention for things that happen in pregnancy is carried by Black women, by all women of color, and by women who live on low income. So I'm worried about the legal risk, even if the health risk for self-managed abortion may not be there. And then the last thing I'll say about giving birth is that it is very clear, demographers and economists have done analyses that show the farther someone has to travel out of state for care, the more likely they are to give birth. And if you look at the map of travel distance to obtain an abortion when there's a ban, and you look at the map of maternity care deserts in the United States, meaning places where there aren't obstetrical providers, where someone may be 2 hours or more from a labor and delivery unit, those maps almost perfectly superimpose. So people will be giving birth who are least likely to have access to obstetrical care. And that is certainly going to worsen the maternal health and maternal mortality crisis that we already face.
Molly, do you want to talk a little bit more about maternal risks as well as racial disparities?
It is really marked, I think, that the entire House of Medicine is behind concern and is speaking with one voice with respect to the need to have access to the full scope of reproductive health care, including abortion. It's just sort of a basic, essential part of healthcare. And if you don't make those necessary health interventions available to people, the weight of that will fall disproportionately on the same groups that have seen disproportionate impact in all sorts of other contexts. And that's true. The AMA agrees. We agree. The American College of Emergency Physicians. This is true all the way across the board. It's a fact that this is what's going to happen.
We've had such an important conversation about the risks, legal and health-wise, that women face, that clinicians face. I wondered if I could ask each of our wonderful panelists to just give us a summary of the kinds of things that you'd like our listeners to be thinking about. Michele, do you want to begin?
I want to leave two notes in history to help people hold on to. And I'm thinking about Dr. King in 1966. He said of all of the inequalities and injustices, injustice in health was the worst. And he said because people could die. And lastly, he was asked why was it that he was speaking to these issues that seemed to be beyond traditional civil rights. And he said, because I refuse to segregate my moral concerns. And I can't think of anything more powerful to think about and to pull all these issues together in these times.
Lisa, do you want to have the next opportunity to summarize, and then I'll turn to Molly?
I actually want to add another dimension rather than summarize, because as an obstetrician, I care for people who continue their pregnancies, not just people who end their pregnancies. And appropriately, our conversation has been about the impact of Dobbs on people who want to end a pregnancy or have early pregnancy complications. But I'm really worried about people who continue a pregnancy, because it was Roe and Casey, both decisions that were, explicitly overturned in Dobbs. It was those two decisions that really said that when a person becomes pregnant, they keep their constitutional rights. They're still constitutional people. Roe said that the state can have an interest in unborn life and preborn life, but not an interest greater than their interest in the life and health of a pregnant person. And then Casey said, yes, the state can have interest in an unborn human, but not greater than the liberty of that pregnant person. So it was Roe and Casey that said, whatever the state wants to do to regulate pregnancy, it can't do that if the life or health or liberty of a pregnant woman is at stake. So I'm worried now, with both of those decisions gone, what does that mean about the government, the state's ability to tell pregnant women what to do or not to? And right now, without Roe and Casey, when a person becomes pregnant, they're basically, constitutionally speaking, not the same person that they were otherwise. And what that means for obstetrical care moving forward, is really kind of frightening.
And of course, there are a lot of states that have restrictive abortion laws that don't carve out the right to health, the right of the pregnant person's health, and that's really crucial to understand. So, Molly, could you just take us out before I bring this conversation to a close?
I will point out that ACOG has been involved in all of the major reproductive health cases in the courts since Roe v. Wade. And in every one of those cases, the argument is based on two principles that really anyone should be able to get behind. It is wrong to have legislative interference in the practice of medicine. Clinicians train for years, they have expertise, they face really complex and nuanced situations, and they need to be able to bring that expertise to deal with the sometimes life-threatening and certainly incredibly important situations that all of their patients face every day. On top of that, it's simply wrong to criminalize physicians for the practice of evidence-based medicine. It is not right to take a profession and ask them to suffer criminal liability for satisfying their ethical obligations. Two very basic principles that apply in all sorts of contexts, and certainly here.
I want to thank our just amazing guests, Michele Goodwin from the Center for Biotechnology and Global Health Policy at the University of California, Irvine, Dr. Lisa Harris, professor in the Department of Obstetrics and Gynecology and the Department of Women's and Gender Studies at the University of Michigan, and Molly Meegan, Chief Legal Officer and General Counsel of ACOG. And I want to convey my deepest appreciation on behalf of JAMA and me personally. This episode was produced by Shelley Steffens and Jesse McQuarters at the JAMA Network. The multimedia team here includes Daniel Morrow, Elena Guobite, Lisa Harden, Audrey Foreman, and Mary Lynn Ferkalak. To follow this and other JAMA Network podcasts, please visit us online at jamanetworkaudio.com. And thanks so much for listening.